Welcome to our January 2015 Employment Law podcast. I'm Karen Plumley-Jones and I'm one of the practice development lawyers for the employment team at Bond Dickinson. In this podcast, I'm going to tell you about some of the major cases that have been reported recently, dealing with holiday pay, employment tribunal fees, obesity and caste discrimination. Then I'll review the employment law changes that took effect this month, as well as those that are due to take place in April. Lastly, I'll have a look at some news stories and give you some action points to take away with you. You can pause this podcast and print a copy of the slides so that you can take notes if you wish. This podcast qualifies for CPD points and you can claim for the amount of time you spend listening to it. I'm going to start by looking at the Employment Appeal Tribunal's decision in the case of Scotland Ltd and others and Fulton and others, where the EAT was asked to decide whether a worker's holiday pay should include non-guaranteed overtime pay and, if so, the extent to which workers could bring retrospective claims for underpaid holiday. 3 different cases were heard together in the EAT because they all raised the same point. All 3 cases involved employees who worked overtime on a regular basis. Their overtime was not guaranteed in that they had no right to a minimum number of overtime hours in a given week, but their employers were able to require them to work overtime if it was available. When they took holiday, they only received their basic pay. The EAT held that payments for overtime that a worker is required to work, but which an employer is not required to offer, is normal remuneration for the purposes of the Working Time Directive, which means that it has to be taken into account when calculating holiday pay for the 4 weeks statutory annual leave required by the directive. This does not apply to the additional 1.6 weeks leave provided in the UK by the Working Time Regulations. However, the EAT significantly limited the extent to which workers can make retrospective claims for underpaid holiday. It held that workers cannot use each shortfall in holiday pay as part of a series of deductions in order to bring an unlawful deductions claim where there is a period of more than 3 months between the deductions. Although the EAT gave the parties leave to appeal to the Court of Appeal, they have said that they will not do so, which means that the EAT's decision stands. The effect of this decision is that employers are now required to include non-guaranteed overtime payments in holiday pay for the first 4 weeks of holiday that a worker takes in each holiday year. This is likely to result in an increase in payroll costs for a number of employers. The decision leaves open how far back workers can go in bringing a claim and the period over which overtime should be calculated in order to work out average pay. Was the government's introduction of employment tribunal fees in July 2013 unlawful? This was the question before the High Court in UNISON and Lord Chancellor and another. Until the 29th of July 2013, employees could bring claims in the Employment Tribunal without having to pay any court fees. On that date, a fee regime was introduced, under which claimants have to pay a fee when they issue a claim, and a second fee when a hearing date is fixed. The trade union UNISON sought to challenge the tribunal fees system by bringing 2 separate judicial review applications in the High Court. Its first application was unsuccessful as the High Court decided that it was premature. It was given permission to bring a second judicial review application when employment tribunal statistics were published that showed a substantial reduction in the number of claims being brought following the introduction of fees. The High Court rejected the second application. While it accepted that the statistics clearly showed that the introduction of fees had had a marked effect on the willingness of employees to bring claims, there was no evidence that they were unable to do so because of cost. UNISON's second judicial review application was therefore dismissed. The High Court's decision may not be the end of the story. UNISON has been given permission to appeal and has indicated that it intends to do so. In addition, it would be open to an individual who had not brought a claim because they could not afford the fees to make a separate application. With the general election taking place in May, it's possible that the issue of fees may be reviewed by a new government, particularly if the Labour Party wins the election. In my third case, Kaltoft and Municipality of Billund, the European Court of Justice had to decide whether obesity was a protected characteristic under the Equal Treatment Directive. Mr. Kaltoft worked as a childminder for the Municipality of Billund in Denmark for 15 years until he was dismissed. He had a BMI of 54, which, according to the World Health Organization classification, made him severely obese. He claimed that his employment had been terminated due to his obesity, and this amounted to discrimination on the grounds of disability. FOA, a trade union acting on his behalf, brought a claim in the Danish court seeking a declaration of discrimination and compensation. The case was referred to the ECJ. The ECJ held that EU law does not lay down a general principle of non-discrimination on grounds of obesity. However, if, under certain circumstances, the obesity of a worker leads to a limitation that results in particular from a physical, mental, or psychological impairment that hinders a person's full and effective participation in professional life on an equal basis with other workers, and the limitation is a long-term one, such obesity can fall within the concept of a disability for the purposes of the directive. The ECJ stated that the origin of the disability is irrelevant. This decision is likely to have a significant impact on employers, who will need to consider their duty to make changes to an employee's working environment to comply with their duty to make reasonable adjustments for disabled employees. Employers will need to be aware of any barriers in the workplace and be considerate towards those who are obese. In addition, employers need to take steps to avoid harassment of obese staff by colleagues, who may take the view that this is harmless banter, in order to avoid claims. My last case is Chandhok and another in Tirkey, where the EAT looked at whether caste was protected under the Equality Act. Ms. Tirkey was a migrant worker from India who was employed as a nanny by Mr. and Mrs. Chandhok. She alleged that they had mistreated her, in part because she was from a lower caste. Mr. and Mrs. Chandhok argued that this aspect of her claim should be struck out because caste was not a protected characteristic under the Equality Act. The EAT confirmed that caste is not a protected characteristic. However, it said that elements of caste identity may form part of an individual's ethnic origin, particularly where caste is determined by descent or contains an identifiable ethnic identity. Therefore, caste discrimination may be prohibited as a form of race discrimination. Employers need to be careful when dealing with any issues in the workplace that may relate to caste, as it is closely linked to race and ethnicity. Cases related to caste will be dealt with by the tribunal on a case-by-case basis, but we now have a binding decision that caste can be included as part of a person's ethnic origin or race. In any event, the government intends to legislate later this year to include caste as part of the protected characteristic of race under the Equality Act, and will therefore make it clear that discrimination on the grounds of caste is unlawful. Next, I'm going to recap on the employment law changes that have taken effect this month. On the 1st of January, new rules on the clawback of bankers' bonuses came into force and apply for 7 years from the date of the award. On the same date, a tax exemption was introduced for employees of up to £500 per tax year, where their employer pays for medical treatment to help them return to work following ill health or injury. The treatment must have been recommended by a healthcare professional as part of the new Fit for Work service, or the employer's own occupational health service. Recruitment agencies and employment businesses operating in Great Britain are banned from advertising vacancies for jobs based in Great Britain, exclusively in other EEA countries from the 5th of January, with some exceptions. From the 8th of January, workers will not be able to bring breach of contract claims in the civil courts for underpaid holiday pay, and from the 10th of January, the recast Brussels regulation will affect where an employment contract can be enforced if there are overseas elements to it. I'm also going to look at the changes that are due to come into force in April this year. Shared parental leave and pay will be introduced and will apply where a baby is due or a child is placed for adoption on or after the 5th of April. Changes to the adoption system will be made on the same date, and paid time off for adoption appointments will be available. Parents of surrogate children will have new rights, and parental leave will be extended to parents of a child under 18. Increases in sick pay, maternity pay, paternity pay and adoption pay are due to take effect on the 6th of April, on which date the basic award, the compensatory award and statutory redundancy pay are due to rise. Consolidation and simplification of the various national minimum wage laws will also take place on the 6th of April. Student nurses and midwives will be included as workers for whistleblowing purposes, and the repeal of the tribunal's power to make wider recommendations in successful discrimination cases will take effect. And now some employment law news items. The government has published a shared parental leave and pay calculator. This can be found online and tells new parents whether they can get maternity, paternity or shared parental leave and how much pay they will get if they take leave. The rollout of the new Fit for Work service started in December when the website and telephone advice line were made available. The referral service, which will carry out telephone occupational health assessments and draw up return to work plans, is due to start shortly and will be phased in by May this year. The government has published guidance for employers, employees and GPs to explain how the service will work, and we have prepared a fact sheet for employers which you can find on the employment page of our website. From the 1st of July, claims for underpaid holiday pay will be limited to a 2-year period. This measure is being introduced by the government to reduce the impact of the Bear Scotland and Fulton case I mentioned earlier. When Lord Smith published his report in November outlining plans for the further devolution of power to Scotland, he recommended that most tribunals should be devolved to the Scottish Parliament. This includes the employment tribunals. There are several action points that you should consider as a result of the matters I've covered in this podcast. Review how you calculate holiday pay and decide if you need to make any adjustments. If you have any obese employees, consider whether you need to make any changes to their working environment and if you need to take any additional steps to prevent harassment by colleagues. Think about updating your equal opportunities policy and training to include references to caste. Update your family leave policies so that you are prepared for the introduction of shared parental leave and pay, and read the government guidance and our fact sheet on the new Fit for Work service. I hope you found this podcast useful. Please get in touch with your usual Bond Dickinson contact if you have any queries. Thank you for listening.